The Chief Judge of Rivers State transfers Amehule's defection case following Inec's position of law on tenure of council chairman in Nigeria. Hello viewers and welcome to InfoGist TV. A swirl of confusion engulfs the Federal High Court in Port Harcourt as journalists and some lawyers arrived to find that the high-profile cases concerning the defection of 25 state lawmakers from the People's Democratic Party (PDP) to the All Progressive Congress (APC) had been unexpectedly transferred. The cases initially heard in Court 4 under Justice Stephen Pap were moved to Court 2 controlled by Justice E.O. Obele. The transfer took place, which caused disarray among attendees who were unaware of the change, and the legal proceedings involving two significant lawsuits, one filed by the both party and others, and another by a local civil society organization against Honorable Martins Amehule and other defendants regarding their controversial party defections. The cases marked under suit number FHC/PHC/269/2004 have attracted considerable attention due to their potential implications on political alignment in the state. The reassignment of the cases followed a petition by Martins Amehule, one of the defendants, to the Chief Judge of the Federal High Court, Honorable Justice John Tosho. Amehule's petition requested the transfer of the lawsuit to a different court, a move seen by some as an attempt to influence the proceedings. Now, when the court convened to resume hearing, Justice Pam reviewed the existence of the petition. We should recall that which explicitly sought to halt the current hearing process, and counsel to the plaintiff, Mr. Ruben Wonogo, argued that the petition was merely a tactic to disrupt the ongoing case and urged the court to disregard it. Conversely, Ferdinand Obiese, representing the defendant, acknowledged the petition and suggested compliance with each request to reassign the case, indicating he was unaware of his client's action. Justice Pam, addressing the courtroom, noted that since the petitioner Amehule had neither filed a motion nor a counter-affidavit and was not officially recognized in the ongoing case, the court had little choice but to dismiss the petition. He proceeded with hearing motions for joinder, emphasizing the need to continue without delay. And further, we are hearing that the Chief Judge of Rivers State has transferred the matter from same court. Meanwhile, Inec states position of law on the tenure of council chairman, and people are wondering if the transfer of the Amehule's 24 defection lawmakers was as a result of the position taken by Inec. Now let's go down to what Inec says the position of law is as to the tenure of chairman in Nigeria. The Independent National Electoral Commission (INEC) has provided clarity on the position of law on the tenure of council chairman. Now, during a meeting with the Inter-Party Advisory Council in Abuja on Friday, INEC chairman Professor Momodu Yakubu revealed that the current chairman and councillor's tenure would expire in June 2026. This current council chairman he talked about is that of the Federal Capital Territory. Yakubu urged political parties and other stakeholders to consider the provisions of the Electoral Act 2022 as amended in relation to the tenure of the area council chairman in the Federal Capital Territory (FCT). According to him, the Act stipulates a 4-year tenure for the chairman and councillors as opposed to the 3 years outlined in the Electoral Act. The Inec boss mentioned that the commission had received inquiries from various entities including law firms, an individual, a political party, and a group of FCT chairmanship aspirants regarding the tenure of the area council. These inquiries also requested the commission to provide the timetable and schedule of activities for the area council elections. Yakubu clarified that the inquiries were based on the Electoral Act 2010 as amended, which was the applicable law during the area council elections held on Saturday, 12 February 2022. It is also worth noting that the Electoral Act 2010, as amended, provides for a 3-year tenure for chairmen and councillors, a development that has fueled speculations that the tenure of the chairman expires next year. Explaining the position of law, however, Yakubu said Nigerians are aware that the National Assembly has since repealed and reenacted the Electoral Act 2010 as amended as the Electoral Act 2022, in particular in the exercise of its power as the lawmaking body of the FCT. The National Assembly extended the tenure of the area council from 3 to 4 years, thereby aligning it with executive and legislative elections nationwide. This is one of the important provisions of the Electoral Act. The Act came into force on Friday, 25th February 2022, 2 weeks after the last area council elections in the FCT, and by the time the elected chairmen and councillors were sworn in 4 months later on 14 June 2022, they took their oath of allegiance and oath of office on the basis of the new Electoral Act, that is the Electoral Act 2022, which provides for a 4-year tenure. Consequently, their tenure, therefore, expires in June 2026. For the avoidance of doubt, tenure is not defined by the date of election, but the date of the oath of office for executive elections or the date of inauguration for Legislative House. This is the Inec chairman saying. For the executive, the tenure belongs to the elected individuals, while for legislatures, the tenure belongs to the legislature. A president and vice president elect, governor, deputy governor elect, senator elect, member elect, chairman elect, or council elect cannot exercise the powers of the office and draw from the remuneration attached to it until such a person is sworn in or the Legislative House is inaugurated. To further illustrate this position, the Commission has since released the timetable for the 2024 Edo and Ondo state governorship elections. This does not mean that whoever wins the election in Edo state in September or in Ondo state in November will immediately assume office. This will only take place after the administration of the oath of office upon the expiration of the tenure of the incumbent holders of the offices. Elections are only held earlier in order to avoid a vacuum. That is why the Constitution empowers the Commission to hold elections not earlier than 150 days and not later than 30 days before the end of the tenure of the incumbent holders of the elective offices. And in the case of the FCT, Federal Capital Territory, Section 108 Sub 1 of the Electoral Act 2022, under which the current chairman and councillors were sworn in on 14th June 2022, is clear and therefore unambiguous. It states 1. That an area council shall stand dissolved at the expiration of 4 years commencing from the date A, when the chairman took the oath of office, B, when the legislative arm of the councillor was inaugurated, whichever is earlier. Again, there are several judicial authorities, including the judgment of the Supreme Court, that tenure begins from the date of oath of office and not the date of the elections. The law firms that have written Inec on behalf of their clients ought to have drawn their attention to both the law and the judicial pronouncement on the matter. You may also wish to note that when the Electoral Act 2022 was signed into law 2 weeks after the Commission conducted the last area council elections in the FCT, The incumbent holders, chairmen and councillors challenged us that we conducted the elections too early, claiming that the new Electoral Act extended their tenure from 3 to 4 years. We reminded them that they took their oath of office under the old law, but before the coming into force of the new Electoral Act. Therefore, their tenure will expire in June 2022. Therefore, I wish to assure you that we are aware of our responsibilities under the law. Section 28, Sub 1 of the Electoral Act 2022 requires the Commission to release timetable and schedule of activities 360 days, that is 1 year, before the date fixed for the election. It cannot be released 2 years ahead of election. Yakubu further emphasized that the Inec conducted area council elections in the Federal Capital Territory, and it serves as a benchmark for local government elections nationwide. He highlighted the significant aspect of providing a stable tenure for both chairmen and councillors. He stated that there has never been a caretaker committee in any area council in FCT. Democratic elections are conducted on a regular basis. There is a plurality of electoral outcomes, as no single political party has ever won elections in all the 68 constituencies. 6 area council chairmen and 62 councillors will continue to uphold the sanity of the tenure and improve the credibility of these elections. May I therefore appeal to all persons with ambitions to contest for the position of chairman and councillors in the FCT to be guided by the provisions of the law and judicial pronouncements on the issues of tenure. I also appeal to the political parties to enlighten their members accordingly. At the appropriate time, the Commission will release the timetable and schedule of activities for the election. In his remarks earlier, the national chairman of the Interparty Advisory Council, IPAC, Yusuf Muhammad Dantele, expressed that they visited the Commission to obtain clarification regarding the duration of the current chairman tenure for the 6 area councils and the 62 councillors in the Federal Capital Territory. He mentioned that although the matter had been resolved previously, whether it was for 3 or 4 years, he believed it was important to involve other stakeholders and gather first-hand information from the Commission regarding the tenure of council chairmen in FCT.